Welcome back to What I Missed TV. Today we are going to talk about Kenneth Copeland, aka Woody. Kenneth Copeland is one of the main witnesses on the YSL RICO trial. Now back on June 7th, 2024, Kenneth Copeland took the stand and pleaded the Fifth. I will not go over the details, but you can watch our previous videos on that particular situation. As we know, the original judge on the case was recused. So now Kenneth Copeland will have to re-testify again. Now in the ex parte meeting, the new judge said that the prosecuting attorneys lied when they said if he pleaded the Fifth, that he would be held in contempt until all the defendants in the other YSL RICO trial court cases are over. When the new judge asked him would he be testifying again, he stated it depends on how he wakes up on that day. This case is a mess. Now let's take a look.
Said that yesterday. So are you waiving the issue of its potential coercion?
And good morning again, Your Honor. I am not waiving that
All right.
issue.
So then how do we handle that?
I thought it's two stages. I was answering your question. If Mr. Copeland resumes testimony, then my understanding of the rule is, or the law, is the way that the court announced, and I think all parties understand it, that once that motion by the Honorable Douglas Weinstein was filed on the 12th, everything thereafter is excluded and we redo it. And that's what we, Mr. Atkins sent an email last night. That's what three of us responded to. I don't want to waive, though, the issue. I thought we should have a hearing with Mr. Copeland to determine did that in camera, if it's in camera, ex parte rather, June 10th meeting, did you feel intimidated, coerced under the Archer case, which from Maryland, I know it's from Maryland,
Right,
that we discussed? And if yes, we were going to ask you then, if a witness was intimidated, that he should not have to testify. You know, he could choose what he wants to do, and then we would strike everything he said.
Okay, well then let's go ahead and find that out. I mean, can you get him here so that we can explore that issue? Because here's the thing is that, yeah, if you know, everything after June 10th, whether the recusal motion was filed or not, that's kind of a separate issue from whether his testimony post June 10th ex parte meeting was coerced. And if it was coerced, then what then? Do we, then how do we still say, oh yeah, but I want, you know, some of that testimony, that's still good.
I thought you, and listen, I have so many, you know, going on. It's just the reality of our case.
Yeah.
But I thought you said that either yesterday or last week, that we will find out whether Mr. Copeland actually wants to testify, continue testifying. And then if he doesn't continue testifying, my understanding of the law is then he would never have been given an opportunity to be cross-examined.
Right.
And therefore you strike all of his testimony. Then you give the command to the jury that wipe out everything that you heard, saw. There were writings introduced, all exhibits are struck, give me your notes.
Right.
That's what I thought. Now,
okay, I just didn't understand because, you know, and thank you for clarifying, because what I was trying to sort out is, are y'all kind of taking the position it was coerced, you know, we have to redo all of it based on the coercion, but then also, yeah, we want to keep parts of it anyway. So if it's a yes, if it was coerced, then we need to redo all of it. Or, you know, find out, does he at this point kind of redo are you intending to take a stand and testify, or are you going to be held in contempt?
That's what I thought.
Okay. All right. Just so sounds like, well, then we're on the same page. Just wanted to make sure y'all weren't wanting it kind of both ways. Ms. Levy, you look like you want to say something.
I was trying to get a full grasp, Your Honor, on everything that was being said. And when I hear that we're looking into whether or not his testimony was coerced, of course I'm going to defer to the court. I would object to that for several reasons. One of which is that the court has had an opportunity to review what went on there. And I believe that based on what is there, right there on the transcript, the court can see, and I believe could make a determination that there's not coercion. So based on the way that the witness has conducted himself, and based on the concerns that we have expressed, the concerns that the witness expressed during prior interviews before I even came onto the case, I would ask that the court not revisit or go back and see, have a hearing on whether or not he felt coerced.
Okay, so this isn't a revisiting of the issue because the issue is live and still pending before the court in Mr. Kendrick's motion and supplemental motion for mistrial and in Mr. Shart's on Mr. Stillwell's behalf revised motion for a fair trial. That's a big claim in both of those motions. And I mean, I just gave you to Friday to respond to them, but and yeah, I think that on the record, it's a legal determination to be made. We don't necessarily need to hear from Mr. Copeland because I'm not sure about Mr. Copeland's credibility on anything anyway, but.
And so for those reasons, I would ask the court to not have us bring him in before that time that he has to testify. I'd also point out that his counsel was present.
I know.
Wow. So thank you for hearing me.
Okay. Well, I mean, I hope that it is not up for debate that some of what was said to Mr. Copeland in terms of potential ramifications if he didn't testify was incorrect. I don't think that there was any kind of, purposeful or nefarious motive in that. But I mean, at least with regard to the notion that he could be held until the trial of even the severed co-defendants was completed, I don't think is a correct statement of the law. If you believe that it is, then please provide me with what you're basing that belief on. But I mean, I also don't think that he paid much attention to that at all. He doesn't even seem to have, he kind of basically moved on from that, but that was incorrect. I think that some of the assertions about statute of limitations potentially were incorrect. I don't think that with regard to he seemed to be worried about a particular crime, the statute of which had apparently already run. But I think that in terms of the notion that he faced no potential jeopardy with regard to crimes based on statute of limitations. I mean, there's the immunity issue, which is wholly separate, but y'all are basically saying you don't even have to worry about it for the statute of limitations reason. They're saying, well, then how are we sitting over here charged with RICO for crimes, the statute of which, when the statute has run on the overt acts, they're in support of the RICO. And I can't remember right offhand what the other potentially incorrect statement was about. But I mean, some of this is or isn't perjury things are a little, I don't think quite exactly accurate either.
Okay.
So I guess what I'm saying is you run a lot of risk, even if I say it wasn't coerced, if that is the legal determination I make. I mean, I'm saying it's a really close call. And it might be better to just pretermit that issue and deal with it a different way.
Okay, so when, that took me to the question I had yesterday, that I thought I had gotten completely wrong with respect to the, motion to compel that we had filed. Because we got to a point where he's trying to not testify. We would of course ask the court to compel him to testify. And the things that have happened. And he was, as I said, he was represented by counsel, as the court has already acknowledged. But I do understand what the court is saying, and I will respond to the motion.
Okay. But I don't want to be dealing, and I can give you to Friday to respond, but I don't want to be us having no idea what we're going to be doing Monday morning. I want it sorted out this week. And your motion to compel was filed when? To compel his testimony. I mean, that was, yeah. And the order was entered on the 7th. And I don't think there's any issue that can still be in effect. I don't think we need to redo that. If you want to redo it, and I'll consider it anew. But, I mean, the more prudent course would really be to just bring him in here like tomorrow and say, and if anybody wants to come up with, he's probably been advised ad nauseum about everything at this point anyway. But given that I just said, I think some of it's incorrect, a correct advisement of here's what the issues are, here's what you potentially face. And we're going to do it in court with everybody in front of us. Y'all can have some input on what he is advised of. Does he have counsel currently? I know he's gotten rid of Mr. Melnick and Ms. Bumpus at this point.
Yes, that's correct, Your Honor. Mr. Melnick withdrew representation. His Bumpus was fired, so no one has said anything to us about a lawyer on his part. So we are unaware of whether he has any representation. And I'd also point out just that since he is still under that immunity grant from the state, my position is that anything what he testifies about would not subject him to criminal exposure. We can't use it. We can't go out and.
Yeah, and I agree that with regard to the immunity, he doesn't, but it's because of the immunity. It's not because there's some statute that protects, some statute of limitation that protects him from criminal liability. It's the immunity that would protect him. And he was not exactly accurately advised as to that, I don't think, at least potentially. Okay. So, I mean, I just think it might be cleanest to give him correct advice as to all of it and then find out what his intentions are. Would that work for everybody?
Yeah.
Can I get an affirmative if that is in fact the case, not just a, like on the record, yes, if it's a yes.
I'll be back to Ms. Williams, yes.
Okay.
Yes. Yes, Your Honor.
Yes, Judge, with the caveat that no party, no state, even though they say it's our witness, not have any communication with that person while he's on the witness stand, which he still is, presumably. Thank you.
Okay.
And Your Honor, with respect to Mr. Harvey's request of the court, I would openly request that the court allow us, because like we have had to transport the witness, I'd request in front of everyone that the court allow us the opportunity to continue transporting him, doing as we have been.
I mean, he's under your subpoena. Y'all the one that needs to get him here, but no substantive conversations. Understand?
Yes.
Okay. All right. And y'all think you'll be able to achieve getting him here tomorrow?
Your Honor.
Can you get him here this afternoon? I mean, No, that's fine, but can you get him here tomorrow?
I believe that we can.
Okay.
And Your Honor, how much inquiry is the court going to allow, or examination?
We don't need to examine him about that. What we need to do, I think, is, given everybody has agreed, is just properly advise him as to what the immunity order means, what the consequences or potential consequences of refusing to testify regardless of the immunity order mean, and find out what his intention is. Okay, so I would love to get from y'all a proposal on what to advise him of. And let's let everybody kind of agree to it before we do it. And then it might not be a bad idea to have counsel for him. I don't know whether he's going to want to hire somebody, or whether he is, I mean, he's not a criminal defendant, so he probably wouldn't be entitled to counsel from the public defender's office, but maybe I can find somebody willing to take it on, whether he can pay them or not. I don't know.
So, Your Honor.
Suggestions?
Your Honor, when the court just said about compelling him to testify regardless of the immunity order, we wouldn't seek to compel it without it because there is potential criminal exposure.
No, I know. I think you might have. I didn't mean to say that. The consequences if he does not testify despite the order. Any ideas about counsel? I mean, I think he's probably entitled to counsel if he wants it to advise him. I don't know. Hadn't done the research on that one.
Your Honor, on behalf of Mr. Williams and I think the rest of the defendants, it seems to me most appropriate for the court to at least inquire of Mr. Copeland himself, whether he is currently represented by counsel or not, and or what his intention is if he is not.
Sure. I mean, yeah, I agree. I guess I can't find that out before he shows up here.
I can have someone who just bring him in.
Okay.
Where he is, so I can actually ask.
All right. I mean, yeah, if we can find him, and even, I mean, I don't care if he shows up by Zoom for me to ask those questions, you know? I mean, that's fine with me. All right, so if he ultimately then says, yes, I'm fine with testifying, then does everybody want to start everything over, have me tell the jury, we're doing a do-over to all of it and start over with him? Or then do y'all want to agree to using some portion of what he's already testified to, some or all of what he's already testified to pre-recusal motion? I can't hear you. Y'all can think about that for a few minutes. Ms. Firstfields let me know that the 6/12 transcript, which was the last outstanding transcript of his testimony, has just been completed and is getting emailed out to y'all. All right, so y'all think, ponder, and in the meantime, do we want to move on to the whatever motions in limine there are about Mr. Zachary? I think you said you had at least a good portion of that ready.
Yes, so counsel for Mr. Stillwell sent over a series of redactions that they'd like to see made, but we have objections to those, and so that is
Okay.
criteria.
All right. That sounds good.
Would the court permit me to just step out?
Sure. Is Mr. Atkins going to take it from here while you're
No,
out?
I'm just asking him about Mr. Copeland and seeing if I can get him on the phone and get an answer to the court today.
Okay. All right. So the Zachary evidence. I have word that Mr. Copeland is here and available right now. So why don't we pause what we're doing with this and have him in, see if he has an attorney, see if he wants an attorney. We don't yet have anything put together that I'm going to advise him of, but
I'm good with that.
we could get through a little bit more of this, tell him to hold tight, take a lunch break where y'all can come up with something. But I could at least find out about the attorney issue right now.
I think that's
Okay. Yeah.
Okay.
Hi, good morning, Mr. Copeland. I'm Judge Whitaker. I think you've been before me before in unrelated matters. But I'm the judge taking over this case now. So go ahead and have a seat. What I want to ask you right now, I know that you have been given immunity with regard to your testimony. And there had been, at some point, you didn't want to testify. At some point, you did want to testify. The first question I have for you.
I know wanted to testify.
Okay. The first, well, right. Want to is maybe the wrong term. But my question for you right now is, do you have an attorney at all?
I don't know.
You don't know whether you have an attorney. I would think that would be a no then if you don't know whether.
I was talking to Melanie, but.
Melnick?
Yes.
Okay. Didn't he ask to be relieved as your attorney, and did you sign something saying that's okay, you can get out of this?
I don't.
You don't remember? Okay. Does anybody know whether that actually occurred?
I don't believe it occurred.
Okay.
I believe that Ms. Bumpus,
I know she was stand-in. And
she was stand-in, and I believe something was said on the record to the effect that Ms. Bumpus was relieved. But
yeah, I know she was.
There was nothing about Mr. Melnick to my knowledge.
Okay. Maybe we.
There was, Ms. Bumpus actually said yesterday, I believe, during her testimony that Mr. Melnick had directed her to tell Mr. Copeland that he could either exercise his,
well, choose not to testify.
Right. Or if he chose to testify, according to Ms. Bumpus.
Yeah, I remember she said, there's this paper I'm supposed to get him to sign. I'm trying to figure out whether it got signed.
So I never got Mr. Melnick off my case.
Okay. So he's still your attorney then?
I guess.
Okay. All right. Well, then that's the answer we've got for that. All right. So I'm going to try to get a hold of Mr. Melnick and see if he can be here with us this afternoon, because some of what I suspect you recall when you were brought into Judge Glanville's chambers with Ms. Bumpus and a couple of the people from the state. And there was a discussion that Ms. Bumpus and Ms. Hilton and Judge Glanville had with you. You asked some questions. They gave you some information. Some of that information was not actually factually correct. And I want to make sure that you have the opportunity understanding what it is that the immunity order means, understanding what the potential consequences are if you do testify or if you don't. We're basically going to kind of start over and
So
do
if I
that
don't
over.
testify,
Huh?
So if I don't testify, how long you gonna hold me in jail?
So, I mean, that's still an issue that you can be held in jail through the end of this trial. But I'd rather have Mr. Melnick here to advise you about the potential drawbacks of and benefits of what, if there are any,
This
of any
trial
of
right
your.
here? To the end of this trial,
Yes.
not the other people.
Not as far as I believe, but the state, what, did you want to do some further research on that?
Yes, just to advise the court
Okay.
of.
Okay, so I just wanted to know, first off, do you have an attorney? Because if you do have an attorney, then your attorney may have some information, advice, and research for me about that. So I want to make sure that I tell you the correct thing about that, okay? So we're going to take a lunch break in a little while, and why don't we plan to have you back here on standby at least. I don't know who was in communication, but we need to reach out to Mr. Melnick, see what his availability is. So just be on standby in case I need you here like at 2 or 3 this afternoon.
2 or 3?
Yeah, because we're about to take a lunch break before too much longer. So you're okay to leave for the next couple of hours, but stay where whomever reached out from the state can reach you to let you know whether you need to be back here this afternoon or potentially tomorrow instead. Okay.
All right.
All right. Thank you. So, I don't know who. Okay, my litigation manager is going to reach out to Mr. Melnick, see if he can get a hold of, see if she can get a hold of Mr. Melnick and find out what his availability is. And depending upon his availability, we'll just see when it is that we have Mr. Copeland back. Because I want him to have the benefit of counsel. And then I also want y'all over the lunch break to work on whatever you think ought to be the correct advice to him. And if you, the state, believe that it is possible to hold him past the trial for which he is under subpoena, then you show me what authority lets you believe that. Okay.
John,
All right. Yeah.
One thing, I think that the transcript reflects this from June 10th, and as well as Ms. Bumpus's testimony yesterday. Mm-hmm. She was emphatic that Mr. Melnick said, if you testify, I'm not representing you. So, and with the fact that Mr. Copeland said.
No, what he said was, if you plead the 5th, I'm not representing you. So I don't know, what that means. I'm just going to reach out to Mr. Melnick, and at least Mr. Copeland thinks Mr. Melnick is still representing him. And if Mr. Copeland never signed whatever that was relieving him, I don't know exactly what their arrangement is, but let's find out from Mr. Melnick.
Yes, Your Honor.
All right. We got everybody? All right. All right. What I know about Mr. Melnick at this point is that he is going to be available by Zoom 3-ish, and he was going to, I didn't talk to him. My lit manager talked to him. So I'm not sure we have a super clear answer on whether he currently represents Mr. Copeland, but Mr. Melnick was going to reach out to Mr. Copeland. And maybe by the time we hear from Mr. Melnick at 3, we'll know the status of that representation. All right. Yes. Am I cold? Is the court cold? No, the court's never cold because these robes are really heavy and hot. So no, but I mean, I realize that it is probably objectively a little cold in here. So I might nudge it up a half a degree for y'all. And then if y'all, okay. Now, there are 2 other thermostats somewhere in this room. And if y'all want to nudge those up, somebody just go back there and do that. That's fine. Okay. All right, so we were, I think, on item number 20. Were you able to look through any more of them? And
So what I was doing was the other assignment, which was to look up the law and to look up what we should tell Ms. Copeland. I don't have.
oh, perfect. Yeah, that's probably more pressing. So, okay. What do you know on those?
So I'll start out with just the fact that the language of the statute itself is part of the basis, well, actually was the basis for the interpretation that we had regarding.
Okay, let me get maybe to the statute. Give me a second to get on Lexis. Unless you have a copy of it for me.
I don't have.
That's fine. It'll just take me a second to get it pulled up. So you're talking about 24.5.507?
Yes, Your Honor.
Okay. All right.
So just the plain language of the statute, so just the plain language of the statute, Your Honor, which is essentially a statute, not saying that the court can grant immunity, but that the state can grant it, and we have to move the court. It lays out very specific steps that we have to take. And in
Hang on a second. Can you not hear her?
Yeah.
All right. Can you, I don't know, do those mics move?
it wasn't on.
Okay.
It wasn't on.
There we go.
So as I was saying, the language of 24.5.507 lays out very specific steps. Only the state can grant immunity, but the court can compel the testimony, which we obviously can't do. And 24.5.507 is a statute that allows us the leeway, the grounds rather, the pathway to get a witness to testify after they have pled
Right.
the fifth. And so section B of 24.5.507 says, if a person refuses to testify after being granted immunity from prosecution and after being ordered to testify as set forth in this code section, such a person may be adjudged in contempt and committed to the county jail until such time as such person purges himself or herself of contempt by testifying as ordered without regard to the expiration of the grand jury. I don't know why it only references the grand jury and not a petite jury, because the top portion of the statute in section A refers to both. And it talks about the fact that if you're needed in a criminal proceeding before a court or a grand jury, if your testimony is deemed by the district attorney necessary to the public interest, then the DA may ask the court to compel that person to testify. In any event, the last line, which says that if the grand jury before which such person was ordered to testify has been dissolved, such person may purge himself or herself by testifying before the court. I don't have the reason that they refer to the grand jury and don't reference the trial jury. But given the fact that the statute itself refers to them almost interchangeably in section A, when they say if you're either brought before the grand jury or a criminal proceeding. And so the fact that even after the grand jury is dissolved, the court can keep you there until you purge yourself of the contempt by giving the court testimony. The extrapolation that I made was you can be kept until you purge yourself of the contempt by testifying, because you don't have a right to assert your Fifth Amendment privilege.
Right. So one thing I would wonder about with regard to that argument is it's sort of a kind of basic canon of statutory construction that if certain language is used in a part of a statute and then it is not used in another part, that there's a reason that it's not used, that there's some significance to at one point saying before a court or grand jury, because they clearly knew they could use different language. So the fact that they didn't include it all in the second part, there might be a reason for it. So that I think kind of cuts against the argument that I can hold Mr. Copeland throughout all three trials. So I think we need, if there's some sort of case law that indicates that if the testimony at issue is before, like for a trial, that somebody can be held even after the trial is over until such time as they decide to come testify in front of a court about it. So
someone sent me a case, but I haven't fully got it. It's in re Long, 276 Georgia App 306. I'm reading it.
Okay. And if anybody on the defense side of the room's got a case that says the opposite, then that would also help us out. You know, that answers the question the other way. It just seems to me like if he's under subpoena for a trial, then the point in which it would logically end would be when the trial is over. And I get he may never still purge himself of the contempt, but
and in re and it's a 2005 case there, so I haven't looked carefully at it, so I don't know if it's cited in the annotations.
it is for a different proposition. Okay. I haven't read it myself either, but I don't know that this case really answers the question we're asking. Anybody have any other kind of case? I mean, my position without a case to say it clearly one way or another is I sort of feel like it couldn't go past the end of the trial.
But it doesn't say.
But I know that. I mean, one way or another, I'm willing to be persuaded differently if we've got law.
Your Honor, I don't have a case on point. However, it would make logical sense that it couldn't go past the end of the trials. However, Mr. Copeland purged himself of contempt at the interim time between two trials.
Yeah, I mean, I guess the same way that they suggest that if the grand jury is over with, you can come purge yourself by testifying in front of the court. Not that either of those really achieves the end that is sought by the immunity order, but it's a way to purge. But, you know,
arguably the testimony would be under oath and available. I'm
It was not going to be available at, I mean,
not at that trial.
Right.
That was, unless, yeah.
so I'm sort of going with through the end of this trial unless somebody tells me differently. All right, has anybody come up with anything else that he ought to be advised about?
Your Honor, I know that the court did advise him that. Westmoreland, can you hear me? I know that the court advised him that he was told some things that were not entirely accurate. And just listening to the testimony and looking at the transcript of what he was told, as the court sits now, are there particular points that the court has concerns about? Because regarding perjury, the statute sort of lays it out. And I know that before he testified, the last time Judge Glanville, I think, gave him a copy of
Ms. Bumpus to give to him, I think.
No, actually, while Mr. Copeland was on the stand, I think.
Oh, in court.
Yes,
okay.
He gave to Mr. Copeland, read to him or gave it to him a copy of the statute and apprised him. I think he made
right. But all of that was before the ex parte. Y'all, it's already too hot, so I'm gonna have to turn it back up.
Okay.
But I went up a whole degree, so I'm seeing if a half degree will make a difference.
I will survive.
What were we saying? Oh, yeah. So that was in court, but then the ex parte occurred after that.
It did.
And much closer in time to when he ended up testifying. So I'm thinking that probably was well, who knows, but that may have been the thing on his mind at the time. So one thing, and I mean, there's, this is he comes in on page, at 10:03, and it goes until 11:30. And I mean, there may have been a break or two in there, but so I realized that it's not just he's told one thing at one point in time, and that's really unclear. I mean, it may be that the gist of it gives him the right information, but for instance, I know there was one thing about perjury that I didn't think was exactly accurate. Just as an example, if I can find it. Okay, so on page 51, the example, and I know what Ms. Hilton means. I don't think that anybody is purposefully trying to mislead anybody. I think we're all, you weren't there by the time Mr. Copeland came in, but I think Ms. Bumpus, Judge Glanville, and Ms. Hilton were trying to make sure he understood. But Ms. Hilton says, your example that you gave me, what if I said I did something and I know you didn't do it and you said before you didn't do it? That's not perjury. That is a prior inconsistent statement. Well, I mean, yes, it's a prior inconsistent statement, but it might also be perjury. It might not be, but, I mean, there'd have to be some, proof that it's a lie. But to say that's not perjury is technically not necessarily correct. And you're also talking to a layperson. And he clearly, I don't think, understands. I mean, he even says, I don't understand any of this at the outset. And, we're talking about purge versus perjury. And I just think we need to make sure we give him clear instructions and then he can make a decision.
Yes, Your Honor. And I know that I think I said on the record regarding his attempt to sort of get that information before he took the stand, when he was trying to speak with Ms. Hilton out there in the foyer area.
Yeah, and then, you know, we also discussed the like immunity versus statute of limitations. And yes, the immunity, because he has been given immunity, protects him from being prosecuted based on anything he says, if he says anything. And that is true. But he was also sort of told, you don't have any statute of limitation worries either. And that's not necessarily true. And it may have no practical effect, because if he can't be prosecuted, he can't be prosecuted, even if it's for something within the statute. Right. But it was technically not necessarily 100% accurate information. Whether he in any way relied on that, I'm not saying that at all. But I just want to make sure we do it entirely, to the extent we can, correctly and accurately.
So would the court be inclined to read him the statute and then respond? I don't know. I'm asking. Respond to questions, because for instance,
sure.
I even heard, it may have just been a misstatement, obviously, and people communicate differently, but when Mr. Melnick was saying regarding how his testimony couldn't be used, but we could use the testimony we can't.
So I don't know. Some people keep saying he's got use, and then some people are saying he's got use and derivative use. So I probably need to look at the order.
I wrote the order, and I literally modeled it after the exact words in the statute. Like, I took the statute and put it in the order for the most part. And so the part of the statute that says that no testimony or other evidence required under the order, or any information directly or indirectly derived from such testimony or evidence shall be used against the person in any proceeding or prosecution for a crime or offense concerning.
That sounds like derivative use to me.
And so that, that was in there from the start. And
all right. And yeah, do you want to, what's the perjury statute?
I will look it up.
And frankly, I'm not sure that either giving him or reading him any of these statutes is going to be particularly helpful. But that's why I would like for him to have counsel, so counsel can explain to him, here's what the perjury statute means. Here's what your immunity order means. Here's what a prior inconsistent statement is. Here is what you face if you decide not to testify regardless of your immunity. And then, sure, if he has any questions of the court, still we can entertain those. But
and I don't know how wise it would be to even make the request that if his counsel seeks to understand the extent to which the immunity exists, like if he would speak to us, but
well, maybe we can dial down from all of that too. That's been several weeks since y'all all made, assertions about whether or not, who knew what when, and who was professional and who wasn't. And maybe I'm going to ask Mr. Melnick and you to move past that. And
I'm beyond it. I would.
You're beyond it. Great. We'll see if he is.
And I would love to be able to fully explain, to allay any fears that he has or concerns about his client's criminal exposure. But 161070 is the perjury.
Okay. And then I ought to know prior inconsistent statements by heart, but which one is that? 24 something. I don't know. I'm sure I have it in front of me somewhere, but I think those would be the four relevant things: the order, 507, perjury statute, and prior inconsistent statements. Whatever, I'll figure it out later. I can find prior inconsistent statements.
246630. Wait. 246613. Witness's prior statement. 246613B.
So Ms. Pursfield's been doing some research, and at least the federal statute on contempt related to kind of their version of immunity is that the confinement can't exceed the life of the court proceeding. So that's sort of, I know we're not the feds, but
Is court proceeding the indictment, or is it the trial of a severed, because if people are severed? Like
I don't know the answer to that.
Jen.
Yes. Yes, I don't, who said that? You did what? Say that again.
Email.
Ah, okay, to Ms. Pursfield, okay. And do you have a short answer for me?
Yeah, we don't just hold people in custody. As U.S. Supreme Court cited in footnote 1 from the Middle District of Tennessee, our issue is a deposition. The person refused to testify. There were trials coming up. They were not set yet. The government's position is like the state of Georgia.
Government's position is like the state of Georgia here. Just hold the person because the case is not resolved. And the Middle District, the district court judge gave reasons. And then the footnote they gave the U.S. Supreme Court that the contempt is punishable for this trial. And after that, we don't do for other trials that are not set. And the government can't continue the same contempt over and over again. They can bring an obstruction of justice indictment against the person or a contempt criminal charge against the person. But we don't just hold people because it becomes, and there's other cases I can send you, at some point it becomes just punishment. The whole point of civil contempt is to coerce the person to do the act.
Right.
And at some point they're not doing the act.
Yeah.
Otherwise, according to Ms. Love, I mean, according to Ms. Love's reading, we could just hold them until it's 50 years later. Yeah.
Yeah.
I mean, at
which
some
can't
point,
be the law.
And
And I know you're not arguing that,
Could
but
the court permit me a moment to just review the case that Mr. Steele just sent over?
sure. Did you send it to everybody?
He did. I got
Okay, yeah.
I just want to read it.
And
Mr. Matthews.
Similarly, is civil contempt, and I'm looking at in re estate of banks. In re estate of banks is going to be 339 Georgia App 144. It says under Georgia law, when the trial court orders incarceration for an indefinite period until the performance of a specified act, the contempt is civil. A trial court, however, may not continue incarceration for civil contempt when the respondent lacks the ability to purge themselves. Imprisonment under civil sanctions is always conditional, and a party found in contempt may apply for release at any time upon a showing of inability to comply. The moment it appears that there is inability, it would clearly be the duty of the judge to discharge the party, because the purpose of civil contempt is to provide a remedy and to obtain compliance with the trial court's orders. The justification for imprisonment is lost when the compliance is impossible.
Thank you. I think you have hit on the exact case we needed. So that answers the question for me. You can look all you want, Miss Love, but I think that pretty clearly answers the question. Logically speaking, that was kind of what I was feeling anyway, but now we got case law to back it up. Good deal. All right. So I am proposing that if Mr. Melnick is in fact representing Mr. Copeland, I asked Mr. Melnick to please make sure he understands the order, the scope of his immunity, which I read to be derivative use as well, and what perjury means, what false statements mean, what could get him either of those charges, legally speaking. And I know Miss Love, you and Miss Hilton had said there are certain things that even. Okay, well, in your discussions conceptually with Miss Bumpus, but I'll leave it with Miss Hilton, had said, I am not intending to charge you with perjury if you do X, Y, or Z. I am intending to charge you with perjury if you do A, B, or C. And Miss Hilton's not here, but you could speak for the state, I would think, as to if there are certain things that you absolutely know, if you say this, and we know we have proof, whatever you need to establish perjury, that you're lying, then we do intend to charge you, if you know. If you get up and say something that's not material, like, oh, the sky's red today instead of blue. I mean, it's not red, it's blue, but who cares? It's not relevant. Then I'm not going to charge you with perjury for that.
And I think that was along the lines of what the intent was, but the intent isn't really an issue. It's the reading it. I'll just say I agree with what the court is saying.
And, if you then say, I don't know, I don't remember, blah, 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 to whatever, every question we ask you, then we will impeach you with prior inconsistent statements. This is what this means. And you don't have to explain that. Mr. Melnick can explain all of that. But I would just propose to make sure that I ask Mr. Melnick to explain all of that. Then he can confirm, yep, we've done that. And then if he has any questions, we'll take questions. And I'm even happy to say, sort of when you get a jury question, we can huddle and go, I'm planning to say this. What do y'all think? If y'all want me to do that, or I'll just wing it either way. If y'all are fine with me winging it, I'll wing it, but don't wing it. Okay. All right. So that's kind of what I'm thinking we do at 3 or 3-ish or whenever we have Mr. Melnick available. And then maybe give him, assuming he is the attorney, overnight to fully advise him of everything. And then we'll have him in maybe first thing and find out what he's intending at this point.
John, I inquired the court regarding the court's earlier statements about the case that Mr. Matthew cited. When it talks about an impossibility, is the court's understanding of that after the trial is over, after this particular portion of this indictment is over, it's no longer possible to purge oneself?
It would no longer be you've said I'd have to have your motion in order in front of you, but as I understand the motion in order at this point, we need his testimony for this trial. Now, you may also need his testimony for some other future trial of some indictee in this indictment. I would think you would need to seek and secure another order. I don't have it in front of me. I can look again, but that is my read on this. You may never try another person. We don't know that. So how can it not be that, as far as we know, he's no longer able to purge once this trial is over?
Theoretically, given Part B of that statute, would he not?
I've made my decision and I get it, but I don't think that, I just don't think that supports your argument. So I think unless and until you can bring me more law, I'm done with it might mean to this part of it. Okay. All right. So let's go back to our narrowing down, figuring out what needs to be redacted out from these statements of Mr. Zachary.
John, may I inquire one more thing? If Mr. Melnick intends to not represent Mr. Copeland, what is our position at that point?
Oh, Mr. Melnick is here now. So he's not here on the Zoom, virtually here. Do y'all all have the Zoom link? You're welcome to, I see that'll show up does it show up on that big screen? All right, so y'all can just watch it on the big screen.
Are you ready for him?
I am. I think I say yes, and yet I think I need to probably turn my camera on. There we go. Hi, Mr. Melnick.
Good afternoon, Judge.
We can't get enough of you. All right, so the reason I have asked again for you to join us, and thanks for doing this by Zoom at very short notice, but so I have essentially determined somewhat with agreement of the parties that we are just going to start over with Mr. Copeland, and he has an immunity. There is an immunity order in place. He has immunity protection. And I plan to bring him in and find out what he wants to do. And I would like for him to be counseled. And I just had him in here a couple of hours ago and asked him if he had an attorney. And he seems to think that you are his attorney still. And so I'm checking in with you to find out whether that is the fact, either still or again. Whether you're going to be representing him, because I'm looking for somebody to just ensure that he is properly advised of what the immunity order means, what he could face contempt-wise, what perjury means, what inconsistent statement means, you know, the typical things you would want to advise your client who's going to be a witness in a criminal case.
Sure. So I've talked to him about all that stuff.
Okay. And so are you his attorney currently?
I am his attorney. Yes.
Okay. All right. So, and you're representing that you have, in fact, already advised him of all of those things?
Yes.
Okay. All right. So I would propose to, unless he just wants to come back this afternoon. I mean, I did think I told him to be available maybe 3-ish. But if you want to be with us by Zoom, but are you available tomorrow to be here in person if we can have him here in person? That way, if he does have questions as anything's going along, and we're not going to take testimony, I just want to find out tomorrow, does he have any questions? Make sure we clear up a few things and then, you know, find out what his intent is as to whether he's going to testify in this trial or not. We're just essentially going to wipe all of what he already testified to and start over.
Your Honor. He should be there right now.
Okay. Oh, he's here right now. Okay. Apparently he's outside. Yeah. So do you want to just stand by with us? And if he has any questions?
Sure.
Okay.
And Your Honor, before he's brought in,
yeah,
I would object to him being asked at this. I'm going to just talk loud.
Your Honor, I would object under all of the circumstances for a number of reasons to him being asked at this point whether or not he is going to testify. There have been so that he's made statements. Obviously, the state has brought him in as their witness to proper testimony against people in the courtroom.
Mm-hmm.
And he's made representations, true or false, he's made them regarding concerns that he has. He's made them in previous interviews with investigators, not just you.
Okay.
So, Your Honor, in the interest of not having sort of the opposite effect on him, and I'm not suggesting the court would, I'm just suggesting that perhaps asking him at this point might have a
when do you propose I ask him? Because if you're, I don't know exactly what you are suggesting, and I could be entirely off, but if you're suggesting that he has, are you suggesting he has safety concerns?
Well, he has made statements about people being willing to have him killed.
Okay. All right. Well, to the extent that those might be any of the people currently on trial, he is at some point going to have to sit in this witness box and say, with all of the defendants present, yes, I am going to testify because y'all are forcing me to because of the immunity order, or I do not care, throw me in jail, essentially. So that's going to have to be in open court in front of everybody. So if that's your objection,
It was just the timing of it.
so would you rather I do it Friday? I mean, I don't understand what it is you want me to do.
It was a preference, but I'm gonna, of course, defer to the court. It's just, as I work through everything that I know has taken place, I'm just trying to make certain that the interests of everybody are protected.
Okay, I'm
not trying to create a.
No, I understand, and I mean I'm just not sure what else I can do it at a later time, but I don't know what that gets us really, other than more uncertainty. And I also realize he may say one thing right now and then another thing right before he is brought out in front of a jury. I don't know. We can still check with him again because we are not at this point having a jury in here tomorrow. So at the point when we get to a jury, if we get to a jury again, then I can ask him again to make sure. I think that would probably be advisable, but everybody's here right now. So I would propose that we do this kind of right now. But before I bring him in, does anybody have anything they want to make sure I make clear with him?
Not for me, Judge.
Okay. So, Mr. Melnick, you weren't here when we had our discussions about what was the outer limit of how long the court could hold him if he chooses not to testify. And it is my belief that the longest he could be held on contempt would be through the end of this trial. So if you need further discussions with him, let me know that.
I don't think so, Judge.
Okay. All right.
And Your Honor, and I know Mr. Melnick obviously knows how to do his job, but he wasn't, and I don't know how much he's reviewed the transcript.
Let me actually ask him, have you reviewed that transcript of the June 10th ex parte?
Mostly. I haven't. I can't say I've sat and studied every single word of it, but I've mostly reviewed it. Yeah.
So, I mean, the defense believes, and I don't necessarily disagree, that there, in addition to a different interpretation of how long he could be held, there is currently a different interpretation of the correctness of the advice about statutes of limitation. And we also think it doesn't ultimately matter because what is protecting him should he testify to something that he did that's criminal is not whether a statute has run or not anyway. It's that he has immunity. But it's possible that a couple of, every statute that you could be worried about has run is not accurate. So, I think you were aware of where in there they said something about a statute, and you're probably aware that there are things he could still be charged with. And does he understand that not every statute has necessarily run on everything he might be criminally involved in, but it doesn't matter because of this immunity order? Or I don't know whether, go ahead.
Yes, Your Honor.
Okay. All right. And then, are you confident that he has a sufficient understanding of what might subject him to a charge of false statements or perjury?
Certainly he does.
Okay. Anything else y'all can think of on either side of the aisle? Okay.
Yes, Judge, can we inquire as to whether or not Mr. Melnick, and I'm sure he has had an opportunity to discuss with him any potential federal ramifications he may have in regards to his testimony here?
Okay. And I my interpretation of the immunity order is use and derivative use. But of course, we're not the feds.
And Your Honor, the court has every ability to do this, but I would object to counsel for the defense.
I've asked them to raise anything that they think we ought to be thinking about. So I invited them to say that. So I don't know whether you want any additional time, having heard that potential issue, Mr. Melnick.
Mr. Copeland and I have had enough time to talk.
All right. Okay. Is there a screen where he can actually see Mr. Melnick over there somewhere? Okay. Thank you. All right. Let's go ahead and get Mr. Copeland in.
You see him under.
All right. Hello again, Mr. Copeland. Your attorney, Mr. Melnick, is with us by Zoom right now. You can see him on the video screen and he can see you. If there's any time you want to talk to him privately, let me know that. And I know y'all have had an opportunity since you and I spoke this morning from the bench and the stand to talk about the fact that the state is not interested in you pleading the fifth. And in order to avoid you pleading the fifth, they have secured an order that says you now can be essentially compelled to testify because we are acknowledging that anything that you say, we cannot prosecute you for a crime other than perjury or false statements based on something that you might say that would otherwise incriminate you if it weren't for this immunity order. And if knowing that you still choose not to testify, the court can and will hold you in contempt. And what happens in that event is that you go to jail. And the length of time that you could be held in jail for, if you don't change your mind and say, okay, I guess I will take the stand, is through the end of this trial. I don't know how long it's going to last. I think previous projections had been February or March of next year. I don't know yet, but I guess that's not outside the realm of possibility. But it would only be through the end of this trial. It would not be through the end of whomever else might be severed from this case and tried later. And I know Mr. Melnick's talked to you in more detail about that. So I want to see if you have any questions of the court about that.
I didn't understand. Now you said at the beginning.
Didn't understand anything. All right. So
no, I'm saying, like, I heard you, but I don't know what you're talking about.
Okay. So tell me what it is that you'd like more information about.
You said something about what they said about immunity?
Yeah.
What you mean?
Okay. Does anybody, I think I've got the order. Mr. Melnick, have you reviewed the immunity order with him?
Oh, you're saying it's the same from last time?
Hang on a second. Yeah. The same one as last time. Yeah.
Yes.
That one. So that's the one I'm talking about. And that is still in effect.
So you're saying that changed?
It has not changed.
All right.
So what has changed is, it's my opinion that I cannot hold you in jail if you refuse to testify beyond the end of this trial. I think you had maybe been told something different earlier. And I don't think that is.
So I ain't got to wait till every defendant that's not here.
Correct. But you would, if you choose not to testify despite this order, you would potentially be held in jail through the end of this trial, which might be February of next year, might be March of next year. I really don't know. It ends when it ends. And the state has 100 more witnesses, and I don't know, any defendant might also have witnesses. So it could take a while, but that would be the end of it, would be the end of this trial. Okay. So do you have any other questions?
Mm-mm.
Okay. And do you want to talk to Mr. Melnick anymore about this particular issue?
No.
All right. So I'm going to ask you right now, because I'm planning to have the jury back on Monday. And I am going to tell them we would essentially start over, because I want you to have a voluntary, to an extent, choice and knowing choice whether to take the stand and be questioned and cross-examined or not, knowing that if you do, other than if you lie, as Mr. Melnick's discussed with you, and it's something the state knows and can prove, they could charge you with perjury or false statements, but they can't, if you incriminate yourself about another kind of crime, they cannot use that to charge you with a crime. And they can't say,
Well, can I speak?
You can, yeah, if you have a
state.
Huh?
I have told the state I have lied and lied and lied and lied.
I know. And
so how are they going to be able to question me?
I mean, that'll be their problem. That's their case to make or not make. I mean, that's not for you or me to worry about. So
they said they're going to be able to charge me if I lie. Like when it's up to them to choose when I'm lying.
Not prior. You've said you've lied and lied and lied in every, I don't know what you've said, but let's even say you've said you lied in every statement you ever gave to the police. If you get on the stand and say that again, or if you say, all right, this one was the truth, that one they cannot charge you with perjury for, because those are things in the past. What they might be able to charge you with is, I don't know. I mean, give me an example of something that you know he didn't do, and well, maybe not. Never mind. Don't do that.
Can I give you an example for what they told me?
Yeah, yes. And then I'll see whether that's what I think or not. Yes.
So she said that the only reason she won't lock me up, I just want to know if it still applies.
Okay.
She said if I do two things, if I plead the fifth and I say that I killed Donovan Thomas.
Okay.
She said if I don't say them two, she will not lock me up.
All right. What was the first one?
Pleading the fifth.
Say it again.
Taking the fifth, Judge.
Taking the fifth. Okay, right. And you can no longer, so taking the fifth means I might say something that gets me in criminal trouble. I might give you evidence against me that you could then use against me. That's what it means to take the fifth, is say, I am not going to give you evidence to use against me to charge me. When they give you that immunity order, immune just basically means we can't do this anymore. It's like if you get an immunization, oh, I'm not going to get the measles now, right? Because I'm immune from it. Because it's like getting you a shot that says, I can admit to a crime on the stand, they can't charge me with it. They have said you no longer have a privilege against self-incrimination because we have committed to not being able to prosecute you, not being able to bring criminal charges against you because of what you say. We cannot take that evidence and use it against you. We can't take that evidence. If you say, well, I committed some crime. Here's what I committed it with. I buried it in the yard. They can't go dig it up in the yard and then say, well, we've got this. They can't use any of that. So that's why taking the fifth at this point would get you in trouble. Being held in contempt is what we
so what if they don't have
call it.
They facts together? Like they saying something that they don't know what they're talking about, and then they ask me about it.
They can ask you about anything they want to. If in your answer you admit to a crime, they cannot charge you with that crime. Now, if you admit to a crime and they have evidence that is pretty certain that you did not commit that crime. For instance, somebody gets robbed yesterday and they have proof that you were in Europe yesterday. There's no way you could have committed that crime, but you say, yeah, I committed that crime yesterday. That was here in Atlanta when they know you were in Europe and they got video of you in Europe and you sent a postcard that said, I'm having fun in Europe. That would be proof that you're lying. And so that they could charge you with perjury for, okay? Or false statements for.
Okay.
Okay. So what I want to know from you is when we have the jury back on Monday and you're still under subpoena, so you're still obligated to come and I'm asking you now, when they're like, all right, we're calling Kenneth Copeland, are you going to say, okay, ask me what you want to ask me, I'll tell you whatever I'm going to tell you? Or are you going to say, nope, I don't care if you throw me in jail, I'm not saying a word, I am not getting on the stand?
It depends on how I wake up.
Okay. All right. Well, then we will just revisit it on Monday morning. So plan to be here at 8:45 on Monday morning. You're free to go for now. All right, Mr. Melnick, please be with us at 8:45 on Monday morning. Can you do that?
Okay.
Thank
I'm
you.
on a trial calendar with Judge Barwick, but I'll notify her what's going on.
All right. Thank you. Appreciate it. All right. So there we have our answer to the extent we have an answer. We will revisit this on Monday morning, which is, by the way, when I plan to have the jury back. And we at least, I have some degree of confidence that he understands what his choices are and what his consequences are.
What are your thoughts so far? Do you think Kenneth Copeland will plead the fifth or testify? Leave us a comment. Don't forget to hit the like button and subscribe to the channel for more content like this.